have the people.
Mr. Keenan, who was approaching behind me.
Record to reflect we've had a bench conference.
Welcome back to Courtroom Uncovered, where real hearings meet raw emotion. Today's case, People vs. Peter Heenan, takes a heartbreaking turn as a once successful man faces the consequences of relapse, heartbreak, and desperation. Watch closely as the judge uncovers the truth behind Peter's struggle with addiction, accountability, and self-deception. This isn't just a courtroom hearing. It's a fight between survival and surrender. Let's see how deep this spiral goes.
Hopefully we can get that all accomplished, and I will adjourn the probable cause in this matter to September 5th. All right. Okay. Mr. Heenan, and the record should reflect, just to briefly set it out, that while we were waiting for the courtroom change, I had a bench conference with counsel, and given those discussions, Mr. Heenan was, prior to calling his case, sent over to Community Corrections to obtain a scram tether and also to take a full panel drug test. Went over, did that, came back a 0.10 on a PBT, could not have the scram tether put on because of that. And also came back in terms of his drug testing with a possible dilution in terms of the creatinine level. Came back positive for benzos, and came back for positives on benzos. Sir, you take Zoloft?
I do, sir.
All right. How long have you had that prescription?
Just started last night. I've taken it before, but I was in jail for 6 days, so I had to stop. And so then I started again. Sorry. The new script is from 2 days ago. Sorry.
Hold on. You got a prescription for Zoloft 2 days ago?
Yes, Your Honor. I did. So rehab, I was in treatment, and they gave me a packet of Zoloft. So I've been using that, but I needed more. So I called my primary care doctor, and he prescribed, I think, 30.
Okay, you had that prescription filled.
Yes, Your Honor. And
so,
delivered.
Hold on. I just need to back up for a moment because I'm trying to find out where you are right now and have a greater understanding. You were in rehab. When did you get out of rehab?
May 12th, I believe.
Okay. And when you got out of rehab, you had Zoloft.
Yes, they send you home with a 30-day supply.
And so at some point, then you ran out.
No, I still have some, but I needed to call my doctor anyway and tell him about this. And so I asked for a refill.
Okay. All right. Where were you in treatment?
West Palm Beach, and it's called Hanley. It's a very good treatment center.
To what?
A very, very good treatment center.
How long were you there?
I was originally 30 days, but I extended to 45 voluntarily.
Was there aftercare that was to follow that?
There was. So I have a therapist. The University of Michigan IOP can't take me for 6 months because I missed an appointment, and that's
because you missed an appointment with them.
Yes, and that's their policy.
Yeah. So since you missed that, they could. Have you been doing anything? Because you were supposed to go and do intensive outpatient.
Yes.
Right. So at the point that you're supposed to go into intensive outpatient, you find out that you can't get in at U of M. What do you do?
So I have SoberLink, and my kids have a GAL. So I'm required to do multiple AA meetings a day.
Okay, but I get that. But in terms of an IOP, I mean, oh, sorry. But just go ahead if you want to try.
Oh, I've reached out to Brighton. They have an IOP program. It's on Zoom now. And I think
Get enrolled?
I can.
Well, no. Here's what I'm trying to figure out. All right. And so I'm asking you these questions for a reason. I'm not asking you to try to trick you into anything. I'm just trying to figure out, like I said, where you are.
Sure.
So you get out of treatment. Part of the aftercare on the treatment program that you're in is that you were supposed to get yourself into an IOP, right?
Your Honor, that was part of the condition. Also, the SoberLink and one AA meeting a day.
Hold on. On whose condition?
Oh, the treatment center's recommendation.
Okay. You got me a little bit lost here. You go into the treatment center in Florida. You come out. They're basically, upon discharging you or releasing you from that, they're putting into place or give you a plan, an aftercare plan, right?
Yep.
Part of that aftercare plan was you were to get yourself into intensive outpatient treatment,
Yes, sir.
right? Their recommendation was something here local at University of Michigan, right?
Yes, sir.
You were supposed to call them, but missed that somehow and or another. And then, as per their policy, you can't get in for a while.
6 months.
Right. After all that happens, what do you do instead of, I don't want to put it that way. What do you then do? Nothing? You didn't get yourself into any type of treatment program. Is that right?
I found a therapist, and no, I did not find an IOP. Your Honor.
Okay. Let me just ask you, and I won't hold you to it only because I know you've been drinking, but why didn't you do that? Honest answer.
Sometimes I feel like AA is more effective because I've done an IOP program before, and it's on Zoom. And sometimes I feel like AA and SoberLink is more helpful, especially in person AA.
Okay. Not yelling at you, but I'm just going to tell you, if you could figure it out yourself, you wouldn't be in the position that you're in right now, right?
Yes, Your Honor.
If it went just on your feelings of what you thought was best, we wouldn't be here dealing with this part of this, would we?
Yes, Your Honor.
So that's why you have other people kind of guide you as to what you really need to do. I also have a feeling that the program that you laid out for yourself, while you think effective, is actually just easier than doing the IOP, because an IOP can be difficult.
I desperately wanted that Michigan ILP 9 to 1, Monday, Wednesday, Thursday. And I just screwed it up.
Right. But then you also then didn't put anything in place once you had messed up.
Right.
And in fact, if you're going to be honest about it, the stuff that you put in place was just easier stuff so that you could say you're doing something.
That's fair, Your Honor.
Yeah, I know. I've seen it for a while. And that's why you weren't going to go into the IOP.
it was the easier path.
Yeah. All right. Mr. Heenan, let me ask you this. You blew a 1-0. When did you stop drinking? When's the last time you had a drink?
So about 4, I woke up and my hands were shaking. So I drank some high noon. And then at
How
7,
much high noon did you have?
just enough till my hands stopped shaking.
Okay, what's that? Tell me what that means.
Like for me, it's like 4 to 6. And then at 7 this morning, when the liquor stores open, I had a DoorDash delivery of more high noon. And I drank again until my hands stopped shaking.
And how much did you have that time?
Your Honor, honestly, I just kept drinking until my hands stopped shaking. It was a 4-pack.
Okay. It was a 4-pack?
High noon comes in 4-pack.
Right. And so did you drink them all?
Oh, yeah.
Okay. And how long did that take you?
I chugged.
Okay. So that DoorDash delivery at 7, that was the last you had?
Yes, and my hands were shaking, so I've got a bunch of empties, and this is how desperate I was. I would pick up all the empties on my table and see if there were sips. And there was one that was like that full, and I chugged that as well. It wasn't.
What? Hold on.
Sorry.
What time did you do that?
It was between 7 and 8 because I knew I had this coming.
Okay.
I didn't want to come in under the influence.
So at 8 o'clock, from 8 o'clock till I don't know what time we first called your case. Well, when you went over to community corrections, so that was around 3 o'clock, maybe somewhere around there. Between 8 and 3, did you have anything to drink?
No, Your Honor. It was 2:30 at community corrections.
Okay, at 2:30. But so from when you chugged that half to 2:30, you didn't have anything to drink.
No, Your Honor. Last night I drank quite a bit though. I lost my boys in a dispute, and I've been on a bender.
Okay. So, Mr. Heenan, I'm just trying to, like I said, I'm trying to figure out where you are and trying to, when you say you've been on a bender, what were you drinking the night before and how much?
White Claw. I drank, probably 15.
Okay. And that would have been last night sometime. When you say that you stopped about 4, you said, or something like that?
I woke up at 4.
You woke up at 4. So yesterday you were drinking White Claw. You had about 15
Yes, Your Honor.
for over just that day, that evening?
All day, yeah.
Okay. And at some point, you stopped drinking. Either you passed out or you just stopped.
Yeah. No, I
You
felt
probably passed out.
passed out, Your Honor.
Yeah. And then you woke up at 4.
Yep.
And then you needed something else.
Yeah, my hands were
Right. I get why. But you needed something else, and that's when you got the other stuff. Or you already had that.
I already had it.
Okay.
I had White Claw and High Noon. I usually when I'm sober, I'm a fit person. I run marathons and stuff. So High Noon and White Claw are the lowest calorie drinks.
Okay. And so then you switched to the High Noon, and you did that, right?
Chugged them.
You're Heenan? Do you think you're in trouble? I mean, just not with the court. I'm not talking about with the court.
This is one of the hardest scenes to watch. Peter's hands are shaking, his voice breaking, and yet, he's brutally honest about his drinking. Legally, his admission of consuming alcohol while on bond is a direct violation, but emotionally, it's a cry for help. The judge's reaction isn't anger, it's concern. When he says, "If I let you out tonight, you won't make it through the night," that's not a sentence. That's a lifeline. Think about it. This is justice with empathy, a system trying to save a man from himself. Do you think judges should take this kind of emotional approach? Or should the law stay cold and impartial? Let us know below.
But just with you and your sobriety.
I do. I have 16 years of sobriety. So I know I can do it. I'm just having a hard time right now with this divorce and losing the kids. And just life is hard right now. You know, I had to resign my job I loved. And it's just been rough.
Okay, so right now you're also not working.
I had to resign to go to treatment.
All right. So here's what I'm just going to let you know that you're going to be staying at the Washington County Jail, temporarily revoke your bond. Okay. And I'm not doing that necessarily as a punishment, but I have no way to release you and keep the community nor you safe. Okay. And I'll just ask you this. You're going to come back tomorrow. Okay. And I'm going to set that for 9 o'clock or 10 o'clock tomorrow morning. When you come back, and I may ask you this tomorrow, but I want to know right now, what would you like to see happen right now for you?
I would like it to scram tether and start taking antabuse.
Okay, Mr. Heenan, is that what you really would like to see happen?
I need some accountability, yes.
Okay, but you also need some help.
Right. I agree. I do have a sponsor.
Have you called your sponsor? No, you haven't. Hold it. Answer my question. Have you called your sponsor?
No, I was too embarrassed.
Yeah. And the reason that you want the scram and the antabuse is because those are sort of easy things that I can do out of sight. Okay. You don't have to answer that.
Okay.
Okay, because I know what's going on. I've been doing this a minute. Okay. Between now and tomorrow morning, here's the thing that you're going to have to do. You're going to need to do the hard work. This isn't going to be easy. And you have to get in your head, because you've done it before, but you have to get in your head that there's not going to be an easy path. This is going to be a hard path for you. And I think you really do know that inside. You just don't want it to come out. People don't come to me whenever they're before me and ask me, give me a hard way to go, Judge. They don't do that, right? So I'm not expecting you to necessarily say that to me. I'm just telling you, this isn't going to be this easy path, this shortcut. And you got to wrap your head around that, right? You just have to understand that. So we're going to try to get something in place for you, because let me put it this way. If I let you out right now, you don't make it through the night without drinking. And you know that.
Not with the scram.
I could put that scram on you. You're going to drink.
I spent.
Oh, you're going to drink.
Okay.
That scram is not a magic bullet. It's not going to stop you. The only thing that scram is going to do, quite frankly, where you are, the only thing the scram's going to do is just tell on you. It's not going to stop you from drinking. Realize that you pounded down 15 White Claws, and then you did 4, then that wasn't enough, and you had to call somebody to bring you more alcohol. Do you think a thing around your ankle is going to stop you after that? No, it's not.
Jail was really hard for me.
I know.
So that alone would stop me.
For a while.
I understand.
But you're going to go tonight, and then we're going to see you tomorrow morning. And Mr. Heenan, you'll never, or maybe one day you'll understand it. I'm not doing it to be me. I don't want to lose you. And I know if I let you out of here, there's a good chance we're going to lose you.
Thank you.
Probable cause conference will be adjourning. I'll just also call it a bond hearing. 2024 at 9 a.m. or as your invite indicates. Anything additional?
Nothing from defense, Your Honor.
All right. Bond will continue. Mr. Heenan? You're looking a whole heck of a lot better.
Thank you so
And
much.
I'm just going to let you know.
What a transformation. Just one night later, Peter appears healthier, calmer, and most importantly, grateful. The judge's tough love clearly made an impact. From a legal standpoint, this hearing reflects a crucial balance. Protecting the community while giving a struggling defendant a second chance. It's a reminder that justice isn't always about punishment. Sometimes it's about redemption. The takeaway? Accountability and empathy can coexist in the courtroom. When a judge listens, challenges, and guides, real change can begin. If you found this case as powerful as we did, hit that like button, drop your thoughts in the comments, and subscribe to Courtroom Uncovered for more real-life moments where justice meets humanity.
Back on the record in the case of people of the state of Michigan versus James Whitley. Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon.
Welcome back to Courtroom Chronicles. Today, we're diving into one of the most tense legal showdowns we've ever seen. State of Michigan versus James Whitley. What starts as a routine hearing quickly spirals into a professional standoff when defense attorney Mr. Bennett is accused of threatening to file a grievance against the prosecutor. But when the judge steps in, everything changes. Stick around, because this courtroom just turned into a lesson on ethics, intimidation, and professional boundaries.
Your Honor, for the record, my name is Jeffrey Bennett, appeared with me at Mr. Whitley sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that, unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern,
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
There were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't.
And why was it said?
Because at the time I believed that it was grievable.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your.
And this is where it all explodes. The judge has had enough. You can hear the frustration in his tone as he calls Bennett's behavior inexcusable, even sanctionable. For context, a judge using that word means a potential formal penalty for misconduct. What's fascinating here is the judge's message. No one in this courtroom, not prosecutor, not defense, gets to intimidate the other side. That's a powerful reminder that the justice system depends on professionalism, not power plays. And honestly, the tension is palpable. You can almost feel Bennett realizing he's crossed a professional line he can't easily walk back from.
Obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. That behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss and you
I did not.
if you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat.
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this. Right.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, that was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule.
I felt this case was different because this is not a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Savage.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in the.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, you know.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess. All rise. Back on the record in the case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
The defendant. So it's very brief. And I don't want to have to bring the lay person back.
understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is.
And there you have it. What started as a procedural hearing became a masterclass in courtroom ethics. In the end, Bennett chose to self-report his own conduct, acknowledging that his message to the prosecutor was inappropriate. The judge, maintaining a firm but fair stance, decided to adjourn the case while weighing potential disciplinary action. Cases like this remind us that justice isn't just about verdicts, it's about integrity in the process. So, what do you think? Did the judge handle it fairly, or was Bennett misunderstood? Drop your thoughts below, and if you found this breakdown as jaw-dropping as we did, don't forget to like, share, and subscribe for more unbelievable courtroom moments and professional legal insights every week.
Barnes and Barnes versus Mahmood and Miller. Your name, sir?
Devin Miller.
All right. And Ms.
Welcome back to another intense courtroom breakdown, and trust me, today's case is anything but ordinary. What begins as a simple rent dispute quickly erupts into confusion, missing payments, emotional conflict, and a shocking personal confession that stops the judge in his tracks. Tensions rise, tempers flare, and the truth behind this couple's struggle finally comes to the surface. Stay tuned, because this hearing goes from financial to deeply personal in a matter of seconds.
Mahmood, is she here or no?
Yes, she is here, but I think she's having some difficulties right now.
Your Honor, we haven't received a payment since the last time we were here. It's $26.65 total. $25.65. I'm sorry.
25.
So I recently just received employment, so I've been waiting for my check to come between that time.
I have a note that $1,000 was going to be paid. I don't know why.
$1,000?
Okay. Well, how would you intend on getting this paid off, sir?
So I don't get paid until the 28th. And then
Until the what?
the 28th of June.
Okay, but all right, let's take that. And how much would you be willing? How much are you going to be able to pay?
So with me working weekly, I get paid $5.60 on a full
On a full check, you get how much?
$5.60 minus tax.
Because I don't know how we're going to do this if she's not here, because I'm about to. I mean, my inclination is to issue a judgment.
Well, we've been having some difficulties in being uncooperative.
Pardon?
She was being uncooperative. I would hope that you don't throw it out because I'm really trying.
She was being uncooperative.
I apologize for interrupting. I have an IM out front, but she doesn't want to come into the courtroom because of a contact order between her and her husband.
We don't have one, sir, Your Honor.
Are you her husband?
Yes. May I explain?
Please.
Okay, so recently she's having a spat with me. She's just upset that she wanted me to apologize for a misunderstanding that we had before coming here to court. When she got verbally volatile with me, so she decided to.
Okay. That's fine. Is there a no contact order between the two of you?
No, there's absolutely not. She probably just said that just to make things worse on my end.
Well, they couldn't get much worse.
Yeah, I don't.
I'm not really sure. She can be very vindictive.
Okay, so let's not say that out loud. Can you go down the hall and,
Sign her into Zoom.
no? She's here. Yeah, well, ask her if she's gonna participate in the hearing. Him over here.
Sir, you have a seat over
And what's your name?
Miriam Mahmood.
All right. There's a total amount of 2565 owing. Was there a method by which you were intending on getting this paid? Or do you know?
I'm going to be very honest with you, Judge.
Okay.
I have no intention of paying one penny. No intention of paying one penny. I've been with Barnes and Barnes since 2021 in this place. I've been with Barnes and Barnes for about 6 years now. Before that, I was in different apartments with Barnes and Barnes. Before that, I've been in EMU since I was 16. Eastern Police, Ipsy Police, all y'all have just failed.
In the end, the judge rules exactly as the law requires, a full judgment for possession and the full balance owed. The defendants now face a strict deadline to pay or move out, and if that deadline is missed, the eviction process becomes unavoidable. This case highlights just how quickly personal struggle and legal obligation can collide inside a courtroom. If this breakdown opened your eyes to the realities behind eviction cases, make sure to hit like, share your thoughts below, and subscribe for more dramatic courtroom insights every week.
Me. I've been begging Barnes and Barnes to fix my house for a simple fan for heat in the winter. I'm having to take money out of my pockets to keep myself fed. I would rather sleep in my car than fight for a house, because along with this court case, I'm dealing with my pedophile dad who decided to touch me for 6 years and get away with it. Along with that, I'm dealing with my mom not cooperating and being in cahoots with him. I'd rather win a settlement than fight for this and give my last tears and blood, sweat, and tears into this. My husband doesn't understand how to speak to me nicely. That's why we're not standing here together. And I'm not gonna stand next to a man who doesn't know how to open the right door instead of the left door and snap at his wife. I'm not going to do that. I walked out because in March, I was in jail for beating him up. I'm not going to stand here and go out of my character and act irate when I don't want to fight for something that's mine. That's not, he claims that it's his more than mine. I brought him into my house. I gave him my car. I gave him the clothes on his back. I'm not going to fight for this anymore. I'm exhausted, tired, and hopeless. Ipsy Police was in my house today at 5 a.m. when I asked for harassment. I filed a PPO. I'm getting no help. I'm hopeless, frustrated, and exhausted, and I'm done.
Okay. I just had to make sure, which is why I wanted it in the courtroom, that I was going to find no tribal issue. I was going to issue a judgment to the plaintiff. And I just wanted to make sure that you understood what the court was doing, which is why I wanted you here. All right. So the court finding no tribal issue, I'll enter a judgment for possession and money. It looks like you requested for possession and money as to both defendants. Total amount, the 25.6, that was inclusive of cost, correct?
Yes.
In the total amount of $2,565. And an order of eviction or writ will issue in 10 days. All right. Thank you.
Sorry, could you say that again? I speak 3 different languages. I'm not American. I'm British. So I didn't understand one word that came out of your mouth. I'm sorry, sir.
The whole thing?
You're throwing legal words at me, sir. I'm mentally,
ma'am.
I'm in
All right.
middle school. I didn't pass, I
Okay.
speak 3 different languages. I'm not educated.
Okay.
So I don't understand when you throw legal terms at me. I need to speak to me like a toddler. I would understand that better. Thank you.
All right. I'm issuing a judgment. I'm signing a judgment, a piece of paper indicating that plaintiff, your landlord, has the right to possession of the premises.
Okay, so
unless $2,565 is paid prior to July 1st or by July 1st. If it's not paid by July 1st, they can then file for what's called a writ of restitution or an order of eviction to have you move. Either at that point, you can move by then or you can pay the money by then. If you fail to move, what will end up happening if they file that order of eviction, the court will sign off on it. And then what will happen is the sheriff, another police agency, or the sheriff's department or a court officer will show up and will, if you haven't vacated the premises, will remove you from the premises.
This is where the entire tone of the case shifts. The defendant doesn't argue the debt. Instead, she pours out years of trauma, frustration, and emotional exhaustion. And suddenly, the courtroom becomes less about rent and more about survival. Her declaration that she won't pay one penny is legally devastating, but emotionally heartbreaking. For the judge, the decision remains the same, but for viewers, this moment raises a powerful question. When life becomes overwhelming, how much should the legal system take into account?